Thank you all very, very much. Thank you, Joseph, for arranging everything. Thank you, my students, some of you, my teachers, some of you, people I have learned from, and people who I'm meeting for the first time. You said that there's still stuff to be done in law and economics. I certainly think so. Indeed, I've just signed a contract for a book. I wrote down 300 pages just of a draft. It may be baloney, but it's on paper, and with the Yale Press, called The Future of Law and Economics. So I think that there is still a significant future and things to be said. One side comment on French and Italian wine. Long after everything I have written, everything you all have written will be gone, one of my great achievements will survive. I taught one of the colleges, one of the oldest colleges in Cambridge, to increase their wine cellar beyond French wine and some German wine to include Italian wine. And that will last long after we're all gone. So we should put our achievements in perspective. Okay. Today, I want to talk about something a little to the side of what this conference is, but I think you'll see how it relates to it. I call it the place of law, of torts in law and economics, the significance of the liability rule. Now, recent years have seen a resurgence of the view of torts as a purely private legal arrangements. Whether it's described in terms of compensatory justice, Jules Coleman, the right of an injured party to be made whole, or redress for civil wrongs, Goldberg and Zipursky, the right of an injured person to get back at the one who injured him or her, these views reject those of the system builders, as Itzhak Englert felicitously called us, those of us who view torts as part of a legal, political, economic structure of a polity. This public view of torts has been dominant, at least since my first article, and Blum and Calvin's answer, Marciano has done a good deal of work on that, aptly titled Public Law Perspectives on a Private Law Problem. It is of the relationship between these approaches and of the inevitability of the public law and economic view of torts that I wish to speak today. In doing so, I want to correct, though, an error that many system builders have made, myself included, that is of viewing torts and its cognates, eminent domain and other such things, as second best ways of mimicking markets. That is, of using that as ways of mimicking markets when markets won't work or are not available. I want to claim a more interesting role, economic role, for torts than that. Interestingly, the new privatists distinguish torts from contract and criminal law by recognizing the public role of the latter, of criminal law and contract, and ignoring their private law, and suggesting instead that torts has only a private role. And they say, if my relationship between victim and injurer are gone, torts is dead. They actually say that. I think that's silly. Torts survives and is alive and well in a system like New Zealand's, that is the public function of torts, in a system like New Zealand, where the victim-injurer relationship is destroyed completely. But let's look at their strangely limited view of contract and criminal law. They view that contract as a market way of regulating the shifting of entitlements. What is mine and what is yours, solely by consent, and surely a contract does that. And criminal law is a command, collective way of regulating entitlements, what is mine and what is yours, by collective decision. And that surely is so. That's the public role of contracts and criminal law. But this ignores a private role of contracts, keeping promises, private human agreements. Why what was called the Holmesian heresy is a heresy. What was the Holmesian heresy? Holmes said that people had a right to break a contract if it was cheaper to break the contract than to follow through on it. And all sorts of people called it a heresy. Now, why did they do that? In a purely public role, Holmes, of course, was right. But what he was saying, but the people who called it a heresy were saying that in some sense, once a contract is entered into, people come to expect something of it privately, and to destroy that is to destroy something too. Similarly, it ignores the private role of criminal law, the right of a victim to invoke the state to punish those who have wronged him. Consider all the victims' rights processes. Why the death penalty exists in the United States, which has nothing to do with deterrence, it has nothing to do with any of those things which have been long shown to be not there, but it remains because of this private notion of my right to get back at him. I don't like it, but the fact that I don't like it doesn't mean it isn't there. Also, it explains why Becker is wrong when he suggests that the only reason for the criminal penalty being more than what was stolen is the multiplier effect, that you don't catch somebody all the time. That ignores a private role of criminal law. To view criminal and contract in this public entitlement defining and shifting functions only is to ignore a significant part of those areas of law. Once relationships are established so that entitlements can change only by consent, or that entitlements can change only when the collectivity decides that they can change, people come to expect some relationships, and those relationships become to have value in and of themselves. And this private side of each of these fields is closely important. And that means that if you only looked at the public side, you would lose something. Now, are these private values, which they emphasize in torts, ones that we can't speak about in economic terms? That's nonsense. Of course we can speak about them in economic terms. They don't, but there is a value that now attaches because people's utilities, to put it in unfelicitous economic language, suffer when promises are not kept, or my utility suffers if I don't get back at a victim. We can put those, or my utility suffers if the one-on-one relationship that they make so much of is destroyed. Of course we can put those in economic terms too. They don't, but we can. But it is a different level of economic than the public side, which people like me and the system builders have been concerned about. And so it is in torts, except that here, the Kohlberg-Gurskys, as I like to call them, aggregation is something that we sometimes do in law and economics and sometimes don't do. The Kohlberg-Gurskys say that there, in torts, it is only the private. And perhaps some law and economics people have acted as if there's only the public side in torts. I haven't, and surely Blum and Calvin didn't way back then. So what is the public side? I have said it before. It is the liability rule. It is the societal decision to let entitlements be shifted, not solely by private agreement, nor solely, as in contract, nor solely by collective fiat, but by private decisions in which the price of the shift is collectively set. Notice the difference. Contracts, private decision entirely. Collectivity, the collectivity decides what is mine, what is yours. The liability rule says you can act privately, but you have to pay a collectively set price, not the price you agree on. And in this respect, torts is only one of several fields that are part of this liability rule system. Eminent domain, privately given eminent domain, are the most obvious. Okay. I've elsewhere written that this has always been available in all societies, whether they are libertarian or collectivist, for practical reasons. That is, there are some things that cannot be handled collectively, even in the most collective societies, and so they use the liability system. There are some things that cannot be handled by contract. It's too expensive to contract, even in the most collectivist, in the most libertarian society. But even more important, even if any given thing could be handled either through contract or in a libertarian society, or through collective decision-making in a collectivist society, you can't handle them all, because collective decision-making gets less and less good as you do too much of it, and the requirements for contractual libertarian dealing, the knowledge required for it, gets more and more expensive as you try to do too much, so there becomes a kind of comparative advantage question of what you want to have decided in one way and what you want to have decided in another way. You may be able perfectly well to decide better than in any other way how many shoes are produced. But since you can't decide everything collectively, even the collectivist is likely to say as to shoes, let it be done in some more private way, because there's more of a comparative advantage to deciding other things collectively. Okay. What is interesting, and I've said this before, is that in many modern societies, the United States and most Western societies today, the liability rule way of doing it is used when it need not be. It is used when we could perfectly well, if we wanted to, decide by contract the shifting of entitlements or decide collectively. That is, it is used when the cost of entering into a contract is low because we're already there. Medical malpractice, where it doesn't work well anyway. Workers' compensation, where you do have a contractual relationship. Product liability. It is used in any number of areas where we could use contracts if we wanted to. But evidently, we, the society, doesn't. And these are areas also where, by and large, you could regulate collectively. In an odd way, this is the analog of the public role of contract and criminal law. That is, when by choice we decide to let entitlements be shifted by contract, when by choice we decide to determine them collectively, and when by choice we decide to let them be shifted in this mixed method in which the collectivity sets the price and then the parties take the actions that they wish. How the collective price is set, or better, what does the collectivity do and mean to do in deciding what that price will be, is what I want to focus on today. It's interesting, and it speaks wonders about the early system builders, myself included, and their economics, and their therefore unspoken pro-market biases, that much early liability rule analysis, my own included, viewed it as trying to mimic the market. Liability rules as remedying market failures. You use it where there are large number problems. You use it where there are transaction cost problems. And you try to do, through the setting of the price, what the contract would do if contracts could be entered into. You try to do that. You try to set the price so that the exchange would be the one that would have occurred if there were no transaction costs. And often you would set the person on whom the liability would be in that way that lessened the transaction cost to correct your error. The whole object was to try to get as close to the market result, because we were all market-oriented. And at times, of course, that is exactly what the liability rule does. But viewing it that way is an impoverished view of both law and economics. There is nothing that requires the view that entitlements should be shifted only and if that is what was consensually desired by the parties. After all, we do have collective determination and command enforcement. That is, there are many things that people want to have determined collectively. So why should we be mimicking the market necessarily? Maybe because I like it, but that doesn't mean the society likes it. As a purely theoretical matter, moreover, and with appropriate knowledge assumptions, as Medina will say in his paper about me, that there was a nifty shift, he says in the middle of his paper, of saying, with perfect assumptions, you reach perfect results collectively just as much as you do individually. And by the way, it was the essence, for those of you who happen to remember, of tenure piece in which he said there is no reason to give compensation in eminent domain if you know that it is worth it or not. Of course not. If you have perfect knowledge, you don't need any of it. Or as both me and Sunstein have said about paternalism, under perfect knowledge, it doesn't matter whether you're paternalistic or not. He's about to give the Storrs lectures at Yale, and I think that's what he's going to say at greater length, given his title. I haven't heard it, but the title, Paternalism and Human Error, suggests to me that what it's going to say again. Okay. But why would we want to have this third-party collective determination? Why would we want to have that? Here, I think we get into something else, which is linked to what I will say much more of in my book. And that is, why would we not want to mimic the market and what the two parties would decide? It is because the collectivity evidently thinks there are some things that are desirable that are not captured in the contract negotiation. And if you speak to collectivists, they never speak of those in economic terms. They always speak of the desires of a collectivity or something like that. If we want to speak about them in economic terms, I think we have to speak about the utility effects on third parties, about the fact that a negotiation between two people to shift an entitlement may have third-party effects, because of which the collectivity enters and sets a price to take those into account. Now, at that point, you start sounding as if you were mimicking the market again, but you're mimicking a very different market from the one that traditionally we did when we said we try to get to the point where the two parties would do this. And by the way, this fact of third-party utility effects is behind any number of fascinating things, and it's behind one of the things that I'm doing in this book. For instance, the existence of so-called merit goods. Why do we have goods that people do not want to have allocated according to the prevailing wealth distribution? Because some people are offended by it. And the people who are offended by it have as much right to that offense and to introducing it into things. Okay. So, one could equally well view the liability rule as approaching or trying to do by private penalties what we can't achieve by total collective mandate, by criminal law. And of course, some liability rules with huge non-insurable punitive damages are sort of mimics of criminal law. That is, there are times when the liability rule, in practice, tries to do in a different way what criminal law can't do. And so we do it through the liability rule because that's what we want. Think of punitive damages, or treble damages, or quadruple damages in antitrust situations or in RICO situations where we don't trust the criminal law system to do it, but we want to do what the criminal law system wants, and therefore we do it by using liability rules to make the entitlement shift extraordinarily difficult. So sometimes the liability rule mimics markets, the libertarian contract. Sometimes it mimics criminal law, and that is punitive damages which are not there for the multiplier effect, the Becker-Sharkey thing of when people don't get caught, or punitive damages that are not there to take into account the extra market value that somebody may put on something because it is his. You know, Viscusi said at one point that it was wrong, I don't know that he said irrational, for people to get punitive damages when their luggage was lost by airplanes. But I don't know if it's right or wrong. If I love my luggage so much that I want to put extra value on it, why shouldn't that, my peculiar utility, be taken into account just as much as if I love my private parts? And I certainly can get punitive damages if airplanes destroy them, in a way. That is, there is this other side of purely contractual, mimic the market punitive damages, like Sharkey's, which is a perfectly explainable in contract terms. But beyond that, beyond either the criminal or the contractual one, is something else. If we view the liability rule, the collectively set price at which an entitlement can be shifted, not as second-best libertarianism, nor as second-best collectivism, but as an ideological middle ground, chosen by the polity because it wants that middle ground, the damages awarded become not a mimic, but a decision in itself. A decision by that social democratic polity, which I may like or may not like, to decide how easy and in what circumstances does that democratic, social democratic society want to make it for you to take from me what is mine, or how difficult we want it to make for you to do that. And that may be for collective desire reasons. Now, as I said, we can term those collective desire reasons taking into account third-party utilities and discuss that in good economic terms, and I inevitably will do that because I can't help myself. That's the kind of economic-y person I am. I'm sure that Dworkin would say I'm nuts, but I've said he was nuts many years and many times, so that's all right too. Viewed this way, one can understand all sorts of things about torts and damages and eminent domain too. Okay. There are times when in fact we set damages below what the real mimicking contract would do. Emotional damages, fanciful damages, purely economic damages. Now sometimes we do that for market mimicking ways, and I don't have time today to go into when those are, but there are certainly times when we do that for market mimicking ways. But there are also times when we do it that way because we want to encourage the shift in entitlements. We want to make it easier. We want to encourage people to do things which take what is mine away from me, or engage in activities that will do that, rather than do the price that would be the negotiated contract price. We want to encourage it. for whatever societal broader reasons. All the times when we do not give punitive damages, where Sharkey and multipliers would say that we should, are situations where that happens. And there are times, instead, when through punitive damages, or allowing runaway juries to give more damages than what would be the market correct ones, and after all, it's our choice to allow such juries to do it, we do the opposites. We want to let individuals decide to take my entitlement, but only if they are willing to chance a very high price. A price that is higher than the price that would be the negotiated interdose between the two of us price. Why? For good or for bad social democratic reasons. Two examples of this from eminent domain will make this crystal clear, I hope. In Italy, for a very long time, I don't know if still, eminent domain compensation paid not market value of land, but value in use. How you were using the land, not its market value. So that if I was using my land as an ancestral farm or estate, even though the value in the market would be much higher because this could be developed, it could be taken either by public eminent domain or private eminent domain for the value in use. Why? Because the collectivity decided that even though I wanted it used that way, there was some more general social good, which could be put in economic terms or not, but which allowed it to be taken from me, paying the lower price. I know that all too well because my great uncle, a great economist, had lands outside Bologna, and he actually was waiting until the development got to the point, he was an economist, where the price was highest. He was not aware of the law of value in use, and somebody looked and said, oh my goodness, we need to build an airport in Bologna, and look at all this empty land that is there. And so my great uncle's land was taken for value in use, and I'm a lot poorer for it. He had no children. I'm well enough off. I mean, I can't argue with a social democrat. Every time I land in Bologna, I say, fine. But let's understand that they didn't pay what that was market worth. The other side came up recently in an eminent domain case, the Kilo case, in which private developers were able to take people's houses in New London under the Connecticut law at the market value of these. And this caused an enormous storm. All sorts of conservatives were saying that the court was being activist by letting the legislature do what it wanted. Some misterms in that, but they were getting at something that somehow it was thought that when private developers had use of eminent domain, they should not be able to take the land paying what would have been a market price, that there was something wrong with that. Conceive of Kilo if the eminent domain price had been 4 or 5 times. If the rule were that when you take for a private development, you may have eminent domain, but only if you pay 4 or 5 times the objective market price. The attitude would have been very different. And that was because there are evidently some collective values, which can be put in economic terms, for that. The interesting thing is if you read, and I have here, the argument before the Supreme Court on that, Justice Kennedy, in his questioning, says, but wouldn't it be all right? Couldn't we do it by making them pay more? And everybody says, that's not the law, that's not the law. But of course it could be the law. And Justice Kennedy was focusing exactly in his questioning. It didn't appear in the opinions, but it is in the questioning at argument. My point of all this is not only to right a wrong in which I early took part. on what a liability rule is and does in practice. That is, of correcting the notion that a liability rule is only a market mimicker. Well, that would be enough to justify this talk. It is also to explain to the Kolburgurskis why torts and its cognates, like contract and criminal law, have a crucial public law economic structure significance from any one-on-one relationship. Each of the things I've described could and would find their place in New Zealand or other system that separated the collectively set price that the entitlement taker paid from the collectively set remuneration that the entitlement loser received. And here I just want to make a parenthetical. What I am saying here is just a small part of what I mean to do in this book I'm writing, which is to try to look at what happens in the world, what kinds of rules of law we have, which are not explained by traditional and simple economic theory, and then say, is the problem with the real world that it is wrong, or is the problem that we are not looking at the world correctly, as with the fourth rule in the cathedral, that we were only looking at appellate cases and not something else? Or is the problem that the economic theory is not sophisticated enough? And that is what I call law and economics, as against economic analysis of law. It is a back and forth between the two. And it is, of course, what Coase did first and foremost in The Nature of the Firm, where he said, if markets were costless, there would be no firms, but there are firms. So what does that tell us about the cost? Can economic theory adapt to that? That's what I want to do in this book in any number of different ways. In this that I'm talking about here is only one small part of it. Okay, so I'll close where I began. There is truth in what the revisionists say, but there is a private side of tort, eminent domain, liability rules, social democratically governed rules of law, just as there is in contracts and criminal law, and just as there is there a system building public side of each. Once, for public policy reasons, one decides that entitlements can be shifted in certain circumstances, in certain ways, people's expectations follows, and people's sense of right and rights versus others do too. So that whether it is because we have set up a contract system, or a criminal law system, or a liability rule system, once we have that, people come to expect certain things, and when they expect those things, it is costly not to follow that to those people. And that is what the private law torts people are emphasizing, and they're right to emphasize that, but it's only a small part. And it is equally true in contracts and criminal law. And then one loses something of crucial importance if one ignores that individual rights created. Holmes's heresy is a heresy, but only in part. Criminal law is in part about victim rights, as well as public ordering. And so is torts about the individual expectations to get compensation or to get back at somebody, but only in part. And the question is the cost of not following that part, of getting rid of that part, high or low in relation to the public ordering part that we want? Is it cheaper to get rid of that private and deal with it in some other way? Not through torts, but through other things in contracts, or through non-insurable torts, or any number of other ways that we can try to deal with those private expectations, if the public part of doing it in one of these three ways is more important in terms of reducing the costs of a harm as against the costs of safety. What these relative costs are, and when it is worth doing one or the other, is for another paper, in another place, and almost certainly by somebody else. At my age, I'm more here to set agendas for other people to do research than to do it myself, to suggest to people what they might do. For today, my point is to glory in the liability rule and its sovereignty in large areas of our legal economic system, in its own right, as a reflection of our, for better or worse, ideologically mixed social democratic societies, where for any number of reasons we want to have entitlements shift, not solely when people would do it by interdose contract, not solely as a result of collective fiat, but when the collectivity decides how easily or how difficultly, for its own reasons, entitlements should be shifted. And what that means for the central role of torts and its cognates in law and economics today. Thank you.